members of the jury, that's all the evidence that you're going to see and all of the testimony that you're going to hear. And what's going to happen at this point is I'm going to instruct you on the law, up to but not including rules for deliberation. And then we'll hear closing arguments, and then I will complete the instructions on the law, beginning with the rules for deliberation, and then you'll go back and deliberate. Please remember not to discuss the case at all among yourselves, or obviously with anybody else, until you actually go back and deliberate. Then obviously you can just speak among yourselves about that, and please don't make up your mind about anything until you've heard everything. That is all of the instructions on the law and all of the closing arguments. And each and every one of you now should have a written copy of the jury instructions. When you do go back into the jury room to deliberate, you'll be able to take with you any and all evidence introduced in the case, your notes, the verdict form, which we'll go over at the very end of the jury instructions, and a written copy of the jury instructions. So the first page is the title page. I'm not going to read that. The second page is entitled Introduction to Final Instructions, and that's where we'll start. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. And I think that most people can process information better if they read the instructions along while I am reading them. If you're the kind of person who processes information better just by listening, then you're more than welcome just to listen. I would ask this, that if you're going to read the jury instructions while I'm reading them, to not read ahead or read behind, but go ahead and read along, okay? Obviously silently. All right, next comes statement of the charge. Michael Drejka, the defendant in this case, has been accused of the crime of manslaughter. Introduction to homicide. In this case, Michael Drejka is accused of manslaughter, a killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Marquise McLaughlin was killed by Michael Drejka, you will then consider the circumstances surrounding the killing in deciding if the killing was manslaughter or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. Number one, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or, number two, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or number three, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I will now instruct you on the circumstances that must be proved before Michael Drejka may be found guilty of manslaughter. I will now instruct you on manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Number one, Marquise McLaughlin is dead. And number two, Michael Drejka intentionally committed an act or acts that caused the death of Marquise McLaughlin. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. And then I will have a more fully developed instruction for justifiable homicide momentarily. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find Michael Drejka guilty of manslaughter, you must then determine whether the state has further proved beyond a reasonable doubt that Michael Drejka carried, displayed, used, threatened to use, or attempted to use a firearm during the commission of the crime. A firearm is a weapon which is designed to, or may readily be converted to expel a projectile by the action of an explosive. I will now instruct you on justifiable use of deadly force. It is a defense to the crime of manslaughter if the actions of Michael Drejka constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Michael Drejka was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself, and he had no duty to retreat and had the right to stand his ground. In deciding whether Michael Drejka was justified in the use of deadly force, you must consider the circumstances by which he was surrounded at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Based upon appearances, Michael Drejka must have actually believed that the danger was real. However, the defendant had no duty to retreat. In considering the issue of self-defense, you may take into account the relative physical abilities and capabilities of Michael Drejka and Marquise McLaughlin. If in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether Michael Drejka was justified in the use of deadly force, you should find him not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Michael Drejka was not justified in the use of deadly force, you should find him guilty if all the elements of the charge have been proved. The evidence which has been admitted to show other crimes, wrongs, or acts allegedly committed by the defendant will be considered by you only as that evidence relates to proof of motive, opportunity, intent, and lack of self-defense. However, the defendant cannot be convicted of a crime, wrong, or act that is not included in the information. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, number one, did the witness seem to have an opportunity to see and know the things about which the witness testified? Number two, did the witness seem to have an accurate memory? Number three, was the witness honest and straightforward in answering the attorney's questions? Number four, did the witness have some interest in how the case should be decided? Number five, does the witness's testimony agree with the other testimony and other evidence in the case? Number six, Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Number 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number 8, did the witness at some other time make a statement that is inconsistent with the testimony that he or she gave in court? And number 9, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to, number 1, whether when the defendant made the statement he had been threatened in order to get him to make it, and number 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Both the state and the defense have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Mr. Rosenwasser, you may proceed with your closing argument.
Your Honor, if we may have a moment, we're having a technical issue. I think we have a computer person outside. They locked the courtroom because of the jury instruction. If I could check.
Okay. Should we give the jury a 5-minute break or? Okay.
He might be able to look at it right away and tell
But
them.
we got to check the sound.
Okay, yeah, if we could.
All right, so we're going to give the jury a short technological break, okay? And then as soon as we're ready, we'll bring you back in.
Yes, Your Honor.